I'm an executor in a current estate lodged with the master's office. The only asset is a freehold property worth about 600,000, which will be inherited by the surviving spouse. This particular individual asking the question says, I'm an estate agent, I'm a paralegal, and I also have a trust account. The master's office, however, is insisting that I pass on the letter of executorship to a lawyer for winding up. The person asking the question also indicates that, look, the surviving spouse has limited funds available to them. And that's why, they're presumably dealing with the matter and not an attorney. And they want to find out, look, am I entitled to wind up the estate as duly appointed executor as myself with, my knowledge of how to go about, wrapping up or winding up an estate? Bruno, what advice can you give this particular individual?
Sure, that's actually so interesting. I've never been asked a question like that before. So the reality behind it is obviously there's a level of skill that's needed in order to wind up an estate, right? An estate worth about 600,000 Rand. So there's two types of winding up that one does need to look at. So there's an administration process that's done for very, very low value estates. And it's something that's almost do it yourself. You go to the master assists you in a certain way. The process is a lot easier, and you basically wrap up the estate quite quickly, or administer the estate rather. But over that amount, it's a normal administration. So there's a whole bunch of requirements that you need to meet, including things like drafting an L&D account, publishing it in the government gazette. So the first thing that we need to look at is whether the person that's actually administering the estate has these skills. Because I can tell you right now, even an attorney doesn't necessarily off the bat have these skills. I've seen many attorneys try and fail. A lot of attorneys just don't try. It's not part of their practices. And there are certain complexities sometimes, especially when it comes to passing ownership over a property. This one seems relatively simple because it's just going to go to the heir. But I mean, you obviously need to check, if there's monies outstanding to any creditors, send out the right notices, etc., etc. And so that's just kind of the first red flag. Make sure that you know what you're doing. Otherwise, you may actually be the cause of the estate taking a lot longer to get wound up. And I've seen people miss advertisements, timeframes, things like that, and actually have to pay double for it. So it also then falls on you, the additional costs. Now, the second thing is, bear in mind, now from the perspective of costs, there are people out there that administer the estate at fixed costs. So if the master's already appointed an executor, and then say that's a family member, there's plenty of service providers that a person can go to in order to negotiate the fees. So the fees aren't fixed at the 3.5% of an estate. It can actually be negotiated. So now that's the second thing to look at. Appointing a person that knows what they're doing at a reasonable fee is definitely a possibility. Not necessarily an attorney. There's guys there that aren't attorneys, but that offer these type of fiduciary services. And now, whether you can actually appoint an estate agent as an executor, I'm not going to lie to you. It's not something that I've experience frequently, because I know that the master expect, if you go to a service provider that assists you, it's your prerogative. So you're giving a person a mandate and saying, please assist, file whatever you need to file. So if the executor makes that decision, it's not a problem. They can appoint whoever they want. Even though I would advise against it, the executor can get anyone to draft something and to lodge it at the master's office. So if the question is, can the executor appoint? Yes. Will the master appoint anyone? Simply appoint a person that's not necessarily a professional, that hasn't dealt with deceased estates to administer it. I highly doubt it, because the master does look for specific professionals that have experience in dealing with these sort of things. And outside the scope of accountants, attorneys, and special fiduciary service providers, the master won't just make an appointment, not themselves, because remember, then it falls on them. If they appoint someone as an executor, they need to be confident this person will be able to actually perform the function. And I don't think it's going to be a case-by-case consideration. They stick to a certain category of people. But I do stand to be corrected. I mean, me personally, I don't administer a lot of estates myself. I've got someone at my office that does that. But yeah, from experience, that is what I found to be the case.